The case of Barnes versus Felix was never supposed to make headlines. It began as a chaotic, high-velocity confrontation on the shoulder of a forgotten highway, a scenario that usually ends in a police report, a funeral, and a sealed file. An officer initiates a traffic stop for a suspected violation. The interaction starts controlled, then disintegrates into panic. The driver hesitates, the vehicle lurches, and in the blink of an eye, the situation goes critical. The officer leaps onto the moving doorframe. 2 shots ring out. A young man bleeds out inside a car that traveled less than 5 seconds. To the casual observer, this was a tragedy. To the Supreme Court, it was evidence of a systemic rot, a legal framework that has been adjudicating life and death decisions with a deliberate, state-sanctioned blindfold. The Barnes family argued that this lethal force wasn't justified by those final, terrifying 2 seconds. They claimed the shooting was the inevitable result of a chain of tactical errors and escalations initiated by the state. The lower courts refused to listen. They applied a narrow, suffocating filter, focusing exclusively on the millisecond the trigger was squeezed. But the Supreme Court was not satisfied with this tunnel vision. In a move that shocked legal analysts, they unanimously agreed that this case demanded a forensic audit of the entire encounter. This isn't just about Barnes. This is about every American citizen who might one day find themselves judged by a system that ignores how they got into the crosshairs in the first place. The moment of threat doctrine that betrayed the Constitution. For decades, the American judicial system has relied on a legal doctrine that sounds reasonable in theory, but operates as a trap in practice. The moment of threat rule. This standard instructed judges and juries to evaluate an officer's use of deadly force based only on the exact instant the weapon was discharged. Nothing before matters. Nothing after matters. Just one frozen, isolated frame of time. On paper, it looks clean. In the real world, it erased the chaos, the tactical failures, and the aggressive escalations that manufactured those final deadly seconds. If an officer could claim they felt fear in that split second, the inquiry ended. Context was irrelevant. De-escalation was irrelevant. Even gross negligence was irrelevant. This is why countless excessive force lawsuits, cases where the state clearly mishandled the situation, died before a jury ever saw them. The system wasn't just narrow, it was rigged. And for years, the powers that be refused to question it. Until now. Why the Supreme Court finally shattered the status quo. This is where the narrative shifts. The Supreme Court did not accept this case to rubber stamp the lower court's dismissal. They stepped in because the math wasn't adding up. They witnessed a pattern of litigation where judges were deliberately blinding themselves to reality. They realized, you cannot adjudicate the constitutionality of a state execution by ignoring the events that precipitated it. Was the situation stabilizing before the officer escalated? Did the officer create the very danger they used to justify the shooting? Was the suspect fleeing or merely confused by conflicting commands? Under the old regime, none of these questions were admissible. The justices saw the existential danger in this logic. It wasn't just a threat to victims. It was a threat to the integrity of the Fourth Amendment itself. So they intervened. Not with a minor adjustment, but with a unanimous 9-0 ruling that effectively ordered the entire federal judiciary. Tear off the blinders and look at the whole ugly picture. The new, full-context legal standard. What the Supreme Court effectively codified is a standard the lower courts should have adopted a generation ago. Instead of freezing the narrative on the final heartbeat before the muzzle flash, the justices declared, "Stop, reality is continuous." They introduced a full context standard, meaning the entire timeline of the seizure is now fair game. The scrutiny is no longer limited to the moment an officer feels fear. The approach, the tone, the tactical decisions, the missed opportunities to de-escalate, the confusion, all of it is now admissible evidence. This standard forces the courts to inhabit the mindset of a reasonable officer, looking at the totality of the circumstances, not a judge replaying a GIF in slow motion. It asks whether the entire chain of custody over that situation was constitutional, not just the final reaction. Frankly, this shift levels the playing field in a way that has been absent from American jurisprudence for decades. It finally acknowledges that these lethal encounters are messy, human events, heavily influenced by the state's actions long before the trigger breaks. What this signifies for every gun owner in America. If you own a firearm, this ruling is not abstract legal theory. It is a survival manual. For years, armed citizens have been judged almost entirely by what transpired in the final, adrenaline-fueled seconds of an encounter. The moment a hand moved toward a waistband, a holster shifted, or an officer panicked. That microscopic lens left countless law-abiding gun owners vulnerable to lethal misunderstandings that had zero to do with criminal intent. One flinch, one misinterpretation, and the law provided the state with a shield of immunity. But the calculus has changed. With this new standard, the courts are empowered to examine the escalation. Were you compliant during the initial contact? Were you following commands? Did the officer misinterpret a lawful action, like informing them of a permit, as a lethal threat? These details are now evidence. This is a seismic shift for anyone who carries. This ruling means you are no longer automatically condemned by a single, frozen moment of confusion. The full narrative of your compliance and the officer's conduct is now admissible. For lawful carriers who simply want to survive a traffic stop, this difference is the line between life in prison and exoneration. A shockwave through the federal judiciary. This ruling didn't just resolve one messy case. It sent a high-voltage shock through every courthouse in the nation. For years, the federal circuits have operated like independent fiefdoms, with some circuits clinging to the moment of threat dogma and others applying a patchwork of conflicting standards. The Supreme Court has now slammed the door on that inconsistency. Every state judge, every federal magistrate must now apply this full context standard. No exceptions, no opting out. This means a tsunami of litigation is about to crash down. Cases that were dismissed under the old rule may be resurrected. Appeals that were dead in the water suddenly have solid ground. Every new excessive force case filed from this day forward will be shaped by this precedent. Judges can no longer summarily dismiss cases based on split-second officer affidavits. Plaintiff attorneys can finally drag the entire timeline into the light. For the first time in modern history, the courts are mandated to view the entire film, not just the final frame. The end of the magic words defense. One of the most critical implications of this ruling is something the courts have rarely scrutinized: pre-seizure conduct. For decades, the legal system treated the moments leading up to a shooting as irrelevant background noise. The only thing that mattered was the fear in the final second. That era is over. Now, the tactical choices an officer makes in the minutes leading up to a confrontation are subject to constitutional review. Did they aggressively close distance on a calm subject? Did they ignore clear signs of surrender? Did they manufacture a crisis and then claim lethal force was their only escape valve? Under this new full context regime, courts must dissect all of it. This introduces a terrifying concept for the state: accountability. Officers can no longer simply recite the magic words, "I felt threatened," if their own reckless behavior created that threat. Lawful gun owners now have the legal maneuverability to present the full reality of an encounter, not just the tragic ending. The collision of the Second and Fourth Amendments. For too long, the Second Amendment and the Fourth Amendment were treated as parallel lines that never intersected. One governed your right to bear arms, the other governed search and seizure. But in the real world, these rights collide violently. Every traffic stop where you are carrying, every welfare check where a holster is spotted, every moment you legally possess a firearm, but an officer misreads your intent. That is where the Constitution is tested. This ruling finally bridges that gap. If you are exercising your Second Amendment rights, the Fourth Amendment must shield you from being treated as a combatant, simply because you are armed. This means officers cannot use the mere presence of a legal firearm as an automatic get-out-of-jail-free card for using force. The courts must evaluate the entire interaction. Did the officer respect your rights before the tension spiked? In simple terms, one right now reinforces the other. You maintain the right to carry and the right not to be assaulted or judged unfairly for doing so. It is a correction that is decades overdue. what this alters in kinetic environments. This ruling isn't confined to law libraries. It changes the physics of the street. It changes what happens at your window during a traffic stop. For the first time, officers on the beat know that their decisions before the weapon is drawn will be dissected in a federal courtroom. That knowledge alone shifts the dynamic of an encounter. When an agent of the state understands that their posture, their tone, and their tactical approach are on trial, not just the final split-second reaction, it forces a more deliberate, calculated response. For the lawful gun owner, this removes a layer of existential dread. No more fearing that a harmless reach for a license or a misunderstood adjustment of a seatbelt will be judged in a vacuum. If a situation goes sideways, the courts are now obligated to look at your compliance, your demeanor, and whether the officer acted like a professional or an aggressor. It strengthens the defense against wrongful charges born from panic. Real-world encounters are chaotic. This ruling finally admits that truth, giving gun owners a fighting chance to be understood rather than condemned by a single frozen moment in time. The road ahead, a new era of legal warfare. The impact of this ruling will not fade with the news cycle. It is going to fundamentally reshape the architecture of state violence for decades. We are not just talking about a memo being sent to precinct captains. We are talking about a total doctrinal rewrite. Police departments across the country are currently scrambling to update their use of force training, not because they want to, but because they have to. They are realizing that the split-second excuse, the shield they have hidden behind for 50 years, has just been shattered. They now have to train officers that every decision they make leading up to the trigger pull will be scrutinized by a federal judge. This is going to trigger a wave of retroactive justice. Courts will be forced to reopen older cases that were dismissed under the defunct moment of threat rule. Attorneys are already drafting motions to resurrect lawsuits where excessive force was buried by bad precedent. Agencies that built their entire operational playbook on the idea that they were immune from consequences as long as they shouted, "Gun!" at the last second are now walking through a legal minefield. For gun owners, the legal landscape is shifting toward accountability. For the armed citizen, the ground has shifted, beneath your feet, finally in your favor. This ruling moves us toward a system of broader accountability and stronger context-based protections. But it also means that staying informed is no longer optional. It is a survival requirement. Every traffic stop, every red flag encounter, every case of mistaken identity will now be reviewed under this new constitutional lens. The Supreme Court has opened a door that the state cannot close. This ruling might feel like distant legal theory, but it changes the kinetic reality of your life. It tells every court in America, context matters, and a citizen's rights do not vanish simply because the situation gets tense. For gun owners and for anyone concerned with the unchecked power of the police state, this is a pivotal turning point. Traffic stops, home checks, split-second misunderstandings, all of it will now be judged with a wide-angle lens, not a microscope focused on a single frame. The era of shoot first, justify later is dead. And that shift finally brings the balance of power back to the people.